Okay, I'll call this meeting to order. Welcome to meeting number 16 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of Thursday, March 31st, the committee is meeting to study Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. Today's meeting will be taking place in hybrid format pursuant to the House Order of November 25th, 2021. Members attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. I'd just like to say, in the interest of time, since we've had votes and started late, I will condense the first rounds to 5 minutes from 6, and the second rounds to 4 minutes, and the third to 2 minutes. So if we reach the third round, I'll try to make sure we reach there. And then, so we'll do them for about 45 minutes each. For our guests, just to let you know, we'll give a 30-second card when your time is about 30 seconds left, and then an out of time. And today I'll have to be particularly precise on timing due to the time constraints. So I'll begin with opening statements. I think we have 3 panelists for the first hour or 45 minutes. We have from Peace Builders Canada, Marlon Marrero, the Executive Director. From Six Nations Police Service, we have Darren Montour, who's the Chief of Police. And from Victim Services of Brant, we have Penny McVicker, Executive Director. So over to you, Mr. Marlon Marrero, for 5 minutes.
Good afternoon, Mr. Chair. Good afternoon, members of the committee and distinguished guests who are also presenting here today. I would like to start off by saying the integrity of the justice system is dependent on the equitable social conditions in which we all live. I'm here today to express Peace Builders' support and provide some advice to Bill C-5 and draw attention to the substantial strides that this bill makes in remedying Canada's response to significant social health issues impacting marginalized communities. For over 17 years, Peace Builders relied on restorative justice practices to encourage reintegration of community with those involved in the justice system. Our restorative justice model addresses the individual and collective experience of systemic marginalization as relates to exposure to violence, mental illness, mental health, systemic discrimination, poverty, and unequal access. Our programs directly respond to the disproportionate number of Black and racialized individuals involved in the justice system. While we understand the causes of over-incarceration are complex and multifaceted, we know that sentences and charging processes play an important role in mitigating the cycle of oppression and connecting individuals to necessary supports and services. Indeed, Peace Builder believes Canada's justice system requires sentences and charging structures which adequately address and respond to the needs of Black justice-involved individuals. We see Bill C-5 as a means of promoting fairer and more just outcomes for Black and marginalized Canadians, while continuing to protect public safety by amending sentencing laws to increase alternatives to incarceration. By no means does this legislation address the historical issues impacting Black and Indigenous folks who are overrepresented in the justice system. It is a step in the right direction. Looking over the wide range of mandatory minimum penalties that have been added to the Canadian laws in recent years, it's no secret that many politicians may feel more comfortable with the idea of eliminating some types of mandatory minimum penalties than others. But discrimination, the undermining of public safety and violations of constitutional rights are problems associated with all mandatory minimum penalties. Not only the 13 of the 72 offenses carrying mandatory minimum penalties dealt with Bill C-5, and the 7 additional offenses partly dealt with by the bill. As countless previous reports and Black and Indigenous leaders have urged across this country, the proposed amendments would move beyond a piecemeal approach and address all mandatory minimum penalties. We believe that you will be making the right decisions in addressing the historical needs of various communities, especially those who are Black and Indigenous, who are overrepresented in the justice system. Peace Builder believes Bill C-5 will address some of the needs, respond to some of the needs in a more fulsome way, while also promoting public safety and improving confidence in the justice system. We hope to see an increased use of accountability measures that are better suited to address the underlying reasons for criminality and thus prevent recidivism. Evidently, the public will benefit greatly from Bill C-5 as a tool to respond in enhancing public safety, support the administration of justice, and save funds for other critical resources. It is through our collective frontline experience, research, and community partnership that Peace Builders can confidently endorse and encourage more work to be done in regards to amendments to Bill C-5 as encompassing reforms necessary to begin transforming Canada's justice system. Consequently, we're calling on the government in Canada to enact and make changes to Bill C-5 in recognition of the need for justice system to do better for Black and Indigenous folks who are overly represented in our communities. This is about providing other opportunities, diversion programs, alternatives to sentencing, ensure that we have safer community than those who are in need of supports that are culturally relevant to integrate back into their communities, have the opportunity and support to better themselves and those members of their families. It is in the best interest of communities that Bill C-5 works to provide judges and other justice officials with the means to be able to support both the community safety and those who are in need of support to address the overrepresentation of Black and Indigenous folks across this country. Thank you.
Thank you, Mr. Morera. Next, we have Darren Montour from the Six Nations Police Service for 5 minutes. Darren.
Thank you, sir. Good afternoon, everyone. Coming from an Indigenous police service myself, and here at the Six Nations of the Grand River Territory, we have seen a drastic increase in violent crimes over the past few years, mainly due to the infestation of illicit drugs within the community. Outsiders are supplying the drugs, and as a result, community members become addicts, resulting in increase in violent crimes. We have also lost numerous community members to fentanyl overdoses in the last few years as well. In my 30 years as a police officer on Six Nations, this violence has become unprecedented. Many community members have died due to the opioid crisis the entire country is facing. Homicides have become increasingly frequent. The root cause of all this is drug addiction, which results in people committing other residual crimes such as break-ins, theft, auto theft, etc., due to feed that addiction. In my experience, sentences imposed by the courts have shown no deterrent against this criminal activity. We have charged the same people for the same drug trafficking offenses several times over, and they still continue to traffic in this community. Rarely is there a custodial sentence for controlled drugs and substances trafficking. In conjunction with the drug charges, traffickers arm themselves with various types of weapons, including firearms that are both prohibited and restricted. None of the traffickers have the proper licenses to even possess these firearms. There needs to be a deterrent from persons committing acts of violence when armed with firearms. Regardless of race or ethnicity, there needs to be a deterrent in place for offenders to realize that the violence in our community and against others needs to stop before any further loss of life. Our Haudenosaunee way of life here at Six Nations is suffering. The recent mental health review of the Ontario Indigenous Police Services contains a comparison of crime severity between Indigenous and non-Indigenous communities. The crime severity index for Six Nations of the Grand River in 2020 was 217.62, compared to Brantford, which was 112.95, Hamilton 93.53, and Toronto at 90.41. The current murder rate per capita in Ontario is 1.59 per 100,000 population. The rate here at Six Nations is 7.79. The proposed conditional sentences for violent offenses will not deter offenders from committing further crimes. We are not in a position to continuously monitor sentenced offenders to ensure compliance of the conditional sentence restrictions handed down by the courts. Police services across the country, and especially those within Indigenous communities, are significantly understaffed. We are continuously asked to do more with less, and we cannot sustain this workload. We are currently faced with officers being off for mental health and mental well-being. This will worsen as time goes on. The Gladue case law for sentencing purposes also has a great influence on whether or not an offender receives a custodial sentence. I can appreciate the statistics regarding the overrepresentation of Indigenous offenders in our jails, but along with the rights of offenders, victims and victims' families deserve rights as well. Gladue has a place in sentencing in certain individuals, but those repeat offenders know the difference between right and wrong, and the sentencing principles under Gladue are exploited to the benefit of these offenders. In my experience growing up and working here on Six Nations, Indigenous communities everywhere, along with here, face the same issues. Intergenerational trauma from the residential school system still plagues our communities. There is a lack of social programs, lack of infrastructure that non-Indigenous communities take for granted. Examples, clean drinking water and housing. And the list goes on. It is more than just improved law enforcement that is needed to better the lives of all Indigenous people in this country. Among Indigenous people, there is a historical inherited lack of trust in the justice system and other federal statutes such as the Indian Act. Colonization has imposed this and other cultural values such as religion and policies on Indigenous peoples that do not favor them. For some Indigenous nations, their way of life is no more. Far too long, our people have suffered under the effects of colonization. We deserve to feel safe, and more importantly, our children deserve to grow up in a community free from violence. I implore you to consider the well-being not only of the people of Six Nations, but of all Indigenous communities on Turtle Island when making your decision on the proposed Bill C5. I'd like to thank this committee for their time today, and I look forward to your final decision on this important matter. Thank you.
Thank you, Chief Montour. Next, Ms. Penny McVecker from Victim Services of Brant.
Hi, thank you. I've been the Executive Director of Victim Services of Brant for over 20 years. We're located in Brantford, Ontario, and part of our catchment area is the Six Nations of the Grand River. I'm here today to speak on the concerns that victims may have around changes in this legislation. In the past year, we've responded to 8 homicides in our community. Many of those have been homicides with a gun, a weapon, and quite a number of those have also been drug-related. We have seen over the last 5 years, our domestic violence numbers have almost doubled, and our sexual assaults have increased by about 20% of those that have been forwarded to victim services. And I think that that's significant to understand that many of, over 40% of the calls to victim services of Brant are gender-based violence. We saw sudden deaths, especially during COVID, are increased by almost 58%, and the majority of those were overdose related, and that had to do with a lot of bad fentanyl coming into our community and people overdosing, many of them just occasional drug users and not understanding the drugs that they were getting and that they might contain fentanyl. I think that, it's really important that I also note that of the incidents that we dealt with last year, we had 427 incidents of breach of probation or breach of conditions. And I think that's important to note because many of those are for domestic violence victims or criminal harassment victims, where victims continue to be threatened and fear for their safety because the offenders are out of custody and are able to access them. And I think that that's one of the things that, as a representative of victims, I would like to make sure that when you're looking at the legislation, you're building in as many protections for victims, especially of gender-based violence, that may be impacted if some of these mandatory sentencings are reduced. We deal with it every day. Safety planning is something that we do repeatedly with victims. We have a number of very serious high-risk victims in our community that even though the offender has been charged and has spent time in custody, they are now out and the victims are still feeling very much at risk for themselves and their families. Once again, I would thank you for giving me the time to speak today, and I'll be interested in any questions that may come forward. Thank you.
Thank you. Thank you to all the witnesses. I'll now begin with Mr. Brock for 5 minutes.
Thank you, Chair, and thank you all to the witnesses for your attendance today. I'm going to start with Chief Montour. Chief, it's good to see you again. Thank you for participating. Chief, you touched upon an important point in your summary. You talked about differences between repeat offenders and first-time offenders. This particular bill, Bill C-5, makes no distinction. It offers the same benefits to first-time offenders as to repeat offenders in terms of opening up or eliminating the mandatory minimum penalties for those significant firearm offenses, the significant drug offenses, and opening up the possibility for further consideration for conditional sentences. So I'd like to know, from your perspective, how this is going to impact policing on the territory and community safety if the current version of Bill C-5 passes without amendment.
Good to see you as well, Mr. Brock. Can everyone hear me okay? I hear an echo. It's going to have an effect here because the victims as well as the offenders 99% of the time are from the Six Nations of the Grand River Territory. And it's a small community, a lot of families intermixed with relationships. And in my experience here with people receiving conditional sentence, there's a lot of times there's a breach in it, like Penny had referred to before. There's breach of probation and breach of any like recogs or form 11s now from the justice, because it's going to have an effect that we're going to be continuously dealing with these people. And in my experience, people reoffend quite often here. And if there's a conditional sentence, that really doesn't do much as far as a deterrent for them, because even they have family members that if the person is breaching, they will not call the police to report anything. And then the victims feel basically that they're left out with no one on their side. And I know Penny has testified to that. And I see that quite often because the first brunt who hears the complaints of all the people is the police here. And we take a lot of heat over that. And then we explain that that's not our call. We've done what we need to do. The courts do their thing and process, and the sentences are handed down, but it's not anywhere near satisfactory to the victims. And that's what I look at, is we're here to help this community. And
I got to cut you off. I got limited amount of time. I do want to get to one more question with you before I turn to Penny. We all agree about the over-incarceration issue. It's a very real issue. My previous career as a Crown attorney, I was always cognizant of that. Can you offer this committee your perception of Indigenous offenders and their respect for or lack of respect of the Canadian judicial system?
In my experience, the majority don't have the respect of the justice system. For the fact is that they see if they're a victim of crime, there's nothing done to the offender. And again, I allude to the fact that victims and offenders are from this community. I've seen, I'm going to call it payback, from a victim's family onto an offender, and we don't need that. Then that just increases the violence. Granted, the Gladue case law does work in certain situations for certain offenders. I've seen it myself in the Indigenous Peoples Court in Brantford. It does work, but for repeat offenders who know the difference between right and wrong, it doesn't. And
Chief. Thank you, Chief. Moving on to Penny McVicker. Penny, Victim Services of Brant provides accessible, confidential, client-centered support for victims of crime. As the Executive Director, can you provide this committee with your opinion on Bill C-5 and the impacts to victims and survivors of crime, particularly in the context of domestic violence, bearing in mind now that the offense of sexual assault now will offer the benefit of a conditional sentence if Bill C-5 passes? You've got 30 seconds.
30 seconds. I would say that I see too many victims that are now not reporting to police because of the fact that they feel like it's a revolving door. They report to the police, they're arrested, and then they're back out on the streets before the victim even has time to get a good safety plan in place. It's a big concern in our community. We have a high number of domestic violence. I think we rank pretty high on the uniform crime reporting for domestics. And I write priority housing letters almost on a daily basis for victims trying to relocate, hoping to find someplace safe that they can live, where their abuser won't be able to find them. The shelters are overflowing because we don't have enough shelter space for women trying to get away from violent offenders.
Thank you, Ms. McVicker. Now to Ms. Dillon for 5 minutes.
Thank you to our witnesses for being here. My question is for Mr. Montour. You spoke about the increase in drug consumption and violence. Can you please explain, in your opinion, why this is the case from what you've been seeing during your work?
Yes, it's with the influx of more and more hardcore drugs like fentanyl, cocaine, the addiction level has increased to the fact that the addicts here in the community, they have no cares of where they get their next fix. And the crimes to help feed that are on the rise, as well as the violence, because we have outsiders coming in that are supplying the drugs, and the traffickers are actually community members here. And at times there's violence against each other, and then there's violence against their spouses, like Penny has alluded to with domestic violence. And more recently, there's a lot of homicides that we've had in the last little while where firearms are involved, and the basis of everything is drugs.
Thank you, Mr. Montour. My next question is for Mr. Marraro. You spoke about keeping young people out of prison. Your program, how does it help youth from recidivism or to even enter the justice system to begin with? Thank you.
Thank you for the question. Our program looks to work with young people on two levels. One, to repair the harm and the relationships that have been damaged through their actions. And two, look for ways in which they can address some of the root causes of the behaviors that brought them to the justice system in the first place. So we work with young people to encourage fulfilling their education, seeking full-time employment and mentorship, and looking at their own psychology of how they think of themselves, their identity, and how they fit and sit within the world that they live in. There are two key points to our restorative justice model. One, repairing the harm caused by an individual, but two, which is not as common, looking at how the system, whether it's the education or justice child welfare system, has impacted on them, and helping young people and their families come to terms with what the damage that has been caused by the system that they exist in, that they have very little power to change. Our program is not about hugging a thug. It's not about not being responsible for your actions. And our program would never say that some people should not be processed through a criminal justice system. What we do say is we need to provide young people and young adults, the emerging adults, especially from 19 to 25, who are overrepresented, who face mental health issues, who face drug use and abuse issues because of trauma that has been caused in their life. Going to the root causes of that and supporting them in their transition to making better decisions for them and their loved ones actually increases, and we've seen this in many cases, increases the safety within our communities. Working at addressing root causes is one of the things that we believe, if the criminal justice system can help to support funding for women programming and family supports, support educational attainment for students and their families, support family reintegration, because many families are separated when they come through, for example, the immigration system. I myself have gone through that process. Those are the kinds of things that we believe help to create safer communities through utilizing a restorative justice model.
Thank you for that response. In your opinion, this tough on crime stance that a lot of people advocate for. Do you think it disadvantages Black Canadians and Indigenous people the most, other marginalized communities? Very recently, a report came out where, for the first time ever, 50% of incarcerated women are Indigenous. If you could speak to us about these two things, please. Thank you.
Absolutely. There is enough science, enough data, enough research that tells us who are filling up our jails, who are being exploited within our child welfare system, who are not gaining educational attainment. We know those are Black and Indigenous racialized folks and communities. This is not by happen chance. This isn't just, it just fell out of the universe. We have systems at play here that continually perpetuate systemic racism. The federal government, our provincial government, and in the city of Toronto all recognize that there is systemic racism. And if we all agree as a nation that there is systemic racism, then we know the individuals and communities that are being impacted by systemic racism.
Thank you, Mr. Marrero. Hopefully you'll be able to answer in the subsequent questions. Next round is to Monsieur Fortin for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I will continue with you, Mr. Marrero. I was very interested in the last part of your presentation where you said the prisons are filled with Blacks or Aboriginals or Indigenous people. You say that that's due to systemic racism, but how is that actually shown? Is that the police will come up with unfounded proof, or our judges are harsher on them than they would be on non-Indigenous? Could you tell us very clearly what, in your view, is the cause for this huge number of people in prison that are either Black or Indigenous?
Give the time again, but can you please put your interpretation? It's on the bottom of your screen. I think it's under options. You can click and there's language interpretation. If you can set it to English, and then you'll be able to, I'll reset your time. Do you have it now?
Monsieur, oui. Monsieur. Alors, je vous disais,
All right, thank you, Mr. Marrero. You said something in your presentation. You said that prisons are filled with Black and Indigenous people, and you are saying that that is due to systemic racism. In your view, why is it that way? Why is it that we find more Blacks and Indigenous people in our prisons? Is it that the police officers send them to prison? Are they too harsh on them? Is it the judges who are too harsh? How do you explain this phenomenon?
Thank you for the question. I would explain this phenomenon in a couple of reasons. We are over-policing particular communities. In the city of Toronto, we have priority neighborhoods that are over-policed, which means young people are coming into contact with police, not in a positive way, but more of a negative engagement. The second thing that I would say is that the trauma that is caused by engagement with particular institutions are creating people to distrust the systems, and sometimes will make bad choices. But one of the biggest things that I think why our jails are filled up with Black and Indigenous folks and racialized folks is the fact that we're criminalizing poor people. We are criminalizing their access. We're criminalizing how they live by not having the means to be able to take care of themselves. And in turn, people sometimes make decisions that may not be in their best interest or in the interest of their families or communities. But we have to agree that Canada has been built on the issues of racism. Our Truth and Reconciliation process that went through, we all agreed that things needed to change for Black and Indigenous folks, And we do know by the reports that there is bias in regards to how young people especially are getting diversion programs or access to support programs within the criminal justice system. The treatment is not the same. And I believe we have enough research and data at all three levels of government that dictate to us, that tells us that this is a problem. It isn't just
Merci,
an
Monsieur
individual problem.
Meraro.
Thank you, Mr. Marrero. I understand your message. In fact, there are statistics that can prove this. I'm not questioning that at all. Indeed, there are a lot of Blacks and Indigenous people in our prisons. But what I am wondering about is why. And in your answer, you said there are perhaps too many police, or you're over-policed. And secondly, you say that people distrust the system. And thirdly, you say that you don't have enough resources, that those people are actually desperate. So that leads me to think the following. Isn't the problem other than minimum sentencing? Isn't it a problem of social integration? Isn't it a question of helping those people who have problems getting special resources? Perhaps we could organize some sessions to make them familiar with the police system, for example. Aren't there those types of things? I'm not a sociologist. I don't want to invent stuff like that. But wouldn't there be something more productive than just abolishing minimum sentences? We can't just abolish that, because if they commit crimes, they're going to end up in prison, be it for 6 months or whatever. It's not necessarily what we want as a society to have these people dealing with that. But isn't there something else that can be done rather than just dealing with minimum sentencing? Aren't there other options?
I agree with some of your points in regards to other options. Providing justices other options around diversion, supported programs are one way of dealing with the issues. And I don't believe I would say that we should abolish all minimum sentences, but I think we need to look at which ones do we need to have and which ones do we need to provide alternatives to incarceration. Where do we fund and support programs that helps young people and adolescents stay out of criminal activity? Just a quick piece. When we think of young people not feeling safe and telling the police that their safety is at hand, and so they go out and protect themselves. This is a reality that young people face in communities. If they don't trust the police in protecting them, they will trust someone else.
Thank you, Mr. Marrero. And next
Merci.
to Mr. Garrison for 5 minutes.
Thank you very much, Mr. Chair, and I want to continue with Mr. Marrero. Something you said struck me at the beginning because it goes against what we often hear here in the committee, both from questioners and witnesses. There's often a presumption that this bill will actually be a threat to public safety. And I think that's sometimes based on, without any evidence, on the idea that violent and repeat offenders would get lesser sentences by eliminating the mandatory minimums. So you said you thought the bill promotes public safety. Could you tell us a bit more about why you think that's true?
I believe the bill promotes public safety to a particular extent. There are, I believe, situations where individuals who are not receiving the kinds of support that they need to receive need to be supported within a different facility. Understandably, and agree. I have worked with young people who have faced mental health, and there are no community supports for those young people. They are not only harming themselves, but they're harming individuals within the community. It's not because they are choosing to, it's because their mental health and their support to address their mental health isn't being addressed within the community. And if we allow for minimum sentences to be placed on those individuals who may not have the options, I could understand how it promotes safety. But we cannot lose sight of the fact that minimum sentences does not guarantee public safety. The individuals, supporting individuals in making a transition from being in the justice system to productive citizens promotes safety in communities. And in no way would I ever advocate for those individuals to be just out on the streets without any kind of conditions, without any kind of supports. We see what happens when they're not supported. Individuals and families get hurt. Communities become unsafe. But to leave all of that weight of society on one individual, I think it's not the Canadian way, because we know as Canadians that it's a complex web of support or not support, and the systems also play a role within the lives of individuals in helping them make or not make decisions. And that needs to be taken into account when justice of the peace or administering justice. And they should have the opportunity to do so.
So we know that with mandatory minimums, the result is a lot of people spending relatively short times in incarceration in provincial institutions. In your experience, does that result in them getting counseling, treatment, or the kind of things they need when they're in provincial institutions for a very short term? Or would they be better off in diversion and conditional sentences?
Very good question, and not as easy to answer, because we do know that when individuals are placed in custody, that programs and services in custody, or even better yet, when organizations like ours and others who are trying to get into facilities to support individuals in their reintegration back into community, that is also a struggle. They're underfunded. It's more around penalizing behaviors than it is in addressing the root causes of behaviors. When individuals are coming out, programs who are working to either mentor, help in educational or life goal planning around employment, etc., most of those programs you will find are year-to-year funding. There isn't a constant resource apparatus set up for organizations like ours and others, Direct Your Life, who work with individuals coming out of the incarceration. There needs to be more emphasis on those supports. That is what creates safety in communities. If our young people and those adolescents have a place to go to help address their mental health, deal with the trauma that's been caused, helping support other positive activities like education and employment, we will have safer communities. But it's not enough just to lock people up. We need to lock people up when necessary and provide support and resources for when they come out. Majority of them will be coming out. What they come out to is going to be a different world, and they may not come out to the resources that are going to help them make different decisions. That has to be addressed if we want safer communities.
Thank you very much. One of the things you also talked about is how this bill doesn't address historic injustices. And one of the things I see missing in the bill is expungement of criminal records. Can you talk about the effect of criminal records in the ability to rehabilitate and work with people?
Oh, the expungement of criminal records is essential to young people, whether they be youth or young adults coming into communities. Most jobs that you will be applying for, if not all jobs nowadays, will be doing a criminal record check. We don't know what on the other side, how those decisions are made with individuals with criminal records. It's a major barrier to employment. Getting it expunged, the cost has been reduced, and that's a good news story. But the process of getting it expunged is also difficult and time-consuming. And
Thank you, Mr. Marrero.
Sorry.
Apologize, I don't feel like cutting you off, but due to the constraints of times. Next, I will go for 2 3-minute rounds. Sorry, I've had to condense a little bit further. First round to Mr. Moore, and for 3 minutes.
Okay, well, I'll address this to Chief Montour. You raised so many great points. Thank you for using the word victims in your testimony, because oftentimes we do not hear about victims, and I'm afraid they're the forgotten group when we're dealing with Bill C-5. But you mentioned about the problem with drugs, with overdoses, and there's a misconception about this bill that it somehow deals with simple possession of drugs, when in fact it eliminates mandatory prison time for drug dealers. The minimum sentence, the mandatory sentence under the Controlled Drugs and Substances Act that target drug dealers, for example, trafficking or possession for the purpose of trafficking, importing and exporting for the purpose of exporting, and production of a substance Schedule 1 or 2, that's heroin, cocaine, fentanyl, crystal meth. Mandatory prison time is eliminated for all of those things. Chief, could you speak to what impact you think that would have on communities, on offenders, and indeed even on morale within the police that are trying to help make our streets safer?
Thank you for the question. It would be very frustrating because we'd be continuously dealing with the same people over and over. And that's been my experience in the last several years. It's the same group of people, even family members that traffic in drugs. And they're trafficking in the serious drugs, fentanyl, cocaine, heroin, and people are dying in this community. And we look to the justice system, and there's got to be some sort of a deterrent, like I said before, because I always speak of the victims, because that's why I became a police officer, to help people in my community. And I know even others coming to this community who are non-community members, they have a right to be protected and feel safe in this community as well. And with the infestation of drugs, there's violence that goes along with that. And seeing that and over again, you can see it in the eyes of the officers here, like, we got to go to this place again and deal with this violence again. So hopefully there's something that comes out of this, that there is a deterrent that stays in place for the simple possession. Yes, we have a drug strategy committee in here to help the people with the addiction. That is forefront to us, is because law enforcement is only one spoke in the wheel to help this community.
And quickly on the issue around guns, you mentioned it, but this bill eliminates mandatory jail time for robbery with a firearm, extortion with a firearm, and possession for purpose of weapons trafficking. You mentioned how there's been an increase over the last several years on these type of offenses. What type of message do you think that will send, eliminating mandatory jail time for those serious gun crimes?
Very
Again,
quickly.
That where's the deterrent to the offenders? Because I've seen it where we have robberies with firearms have increased due to the drug addiction. Homicides with firearms are prevalent nowadays in this community, as well as other communities in and around the Six Nations of the Grand River Territory. And again, I go back to the victims. How do the victims' families feel if someone is convicted of a serious firearms offense and they're their neighbor and that person is on a conditional sentence? Like, again, then we deal with the fallout of redemption from the victim's family next, and that has happened here in this community.
Thank you. Thank you, Mr. Moore. Next to Madam Diab for 3 minutes.
Thank you very much, Mr. Chair, and thank you to all the witnesses for appearing as we continue to talk about Bill C-5. Today in Parliament, on Parliament, we have Science Meets Parliament, and I actually have guests with me that are listening to these proceedings this afternoon. So much of what we've heard on this act goes to, facts and evidence and science and reports. So I just have a question with my less than 3 minutes here to Mr. Marrero. The Gladue reports and the impact of race and cultural assessments, according to facts, and what we have seen in many provinces and jurisdictions, help judges to understand the role of systemic racism in bringing someone before the courts. But mandatory minimum penalties of imprisonment impose a one-size-fits-all approach to sentencing that prevents them from using that information to craft a fit sentence. Can you tell us why judicial discretion, in your opinion, based on your 25 years of experience working with young people, is important to ensuring that people receive appropriate sentences that take into account all of their circumstances?
Thank you for that question. Taking into account the individual's life circumstances is very important to addressing the root causes and helps justices make much more informed decision. One of the stats that I would just like to throw out, and this is in regards to women, 86% of women in federal prisons have histories of physical and or sexual abuse. In the work that we do with children and youth, and with youth, we know that young people who are in the child welfare system are also young people who are in the justice system. They face family separation and trauma, and now they're in the justice system with sometimes no idea, justices, of the history of this young person in regards to their addiction, in regards to the trauma that they're faced, and why they may be standing or sitting in front of a justice today. It's vitally important that justice officials have this information and take the whole person into account when rendering their decisions. It allows for opportunities for those young people to be able to address some of the historical harms that they have caused. And we would advocate and continue to advocate for that type of information to be within the process, within the justice process, so that judges are able to make the proper informed decisions.
Thank you. And with 15 seconds left, I will give it to the next witness to ask.
Thank you,
colleague.
Madam Diab. That actually concludes our first panel, so I'll just suspend for 30 seconds for a quick sound check, and I think the in-person witness...
Monsieur le Président, on n'a pas nos 2 minutes, monsieur?
Mr. Chairman, we don't get 2 minutes?
Only 35 minutes, Madam. So I want to get you a good round in the next question, so we'll make sure you get it. Okay. Witnesses, again, you have 5 minutes to make your opening statements, and I have just quick little flashcards. When there's 30 seconds remaining, I'll post this, and when you're out of time, I'll post this, and please wrap up accordingly. So beginning, we have Sarah Dover as a lawyer, as an individual. We have from the Criminal Law Association, Leo Romano, Senior Defense Counsel, Adam Weisberg, lawyer and secretary, and in person here today we have from the Federation of Asian Canadian Lawyers, Justin Ewan, criminal defense lawyer. So I'll begin with Sarah Dover for 5 minutes.
Good afternoon. Thank you so much for inviting me to come and present. It feels today a little bit like I've crawled up from the grit and grime of the front line of the criminal justice system, and I'm now sitting in polite company, not quite sure what fork to use. So any day in those frontline criminal courts, you are going to encounter a parade of people who suffer from mental health and addiction issues, poverty, and are racialized. So great days for me as a lawyer might involve clever word algorithms about charter rights or evidence law or mandatory minimum sentences. But the more common experience is a persistent pounding of institutional failure in the lives of vulnerable people. So a homeless client in full psychosis, discharged from jail wearing an orange jumper holding a bus ticket. A client found naked and unconscious in a park, rejected by a women's shelter for a history of being behavioral. A client so sickened by his own actions and the prospect of a mandatory minimum sentence that our time together is spent just de-escalating his suicidal ideation. A pregnant client released from jail with nowhere to go, who asks me for a ride to her street daddy's house. These terrible days are punctuated by truly awful, defining days that define me as a lawyer and a person. Those are the days looking down on a client in a casket, sending someone's jail art to their mother following an overdose death, or sitting with a client in jail who's having to make an end-of-life decision for their sick child, or eulogizing a client with their family, remembering their joy and their laughter after they were murdered. They don't teach this stuff in law school. How to get heart punched and still be capable of finding words that sound sensible in polite company. So to see a person at sentencing only for what they did, I truly believe is a type of violence. The story is never so simple as just the offense. The issue is not just whether people's stories will matter in the face of a looming mandatory minimum sentence, because humans always live fully dimensional lives. The issue is whether the sentencing process itself will matter. See, the way in which stories are told, unfold, and are woven together make the sentencing process meaningful for everyone and the legal system. Don't you see? Legal systems are stories that are shared out in the open so that societies can create, yes, public legal institutions, the rule of law, but more to create meaning from what has happened. So transitional justice, it's an area in international law. It includes truth commissions like the TRC, the Inquiry, RCAP, reports and commissions that have offered us truths, national level stories to move us forward from systemic racism. The awful things that have happened to children who have died or survived, the life stories and present day lived experiences of Indigenous clients they've shared with me. I don't represent them in this forum, but I remember them. I remember pins in tongues and bullying in school and sport, grinding poverty, a lack of clean water, treaty and inherent rights ignored, land defenders arrested, homelessness, underhousing, racist policing, money for social programs diverted into litigation, the whole thing. To say that none of that should matter at sentencing or at any time leaves us with a story about our justice system, which is called systemic racism. This bill endeavors to make improvements to the criminal justice system. It is a step in the right direction, but a very modest one. A stronger bill would be express UNDRIP compliance, Indigenous self-determination. It would wholly implement the recommendations about mandatory minimum sentences that were issued by the TRC and the Missing and Murdered Indigenous Women's Inquiry. So in closing, it has been the honor of my life to come into relationship in some modest way to the stories of the people and the communities that I have worked with. I am grateful and humbled for the meaning that they have brought to my life. And I hope that you will make improvements to this bill to change the story of our justice system, how it treats vulnerable and marginalized peoples, and how it shapes our relationship with Indigenous peoples and nations. Thank you.
Thank you, Ms. Dover. Next, we have, I believe, Mr. Rousseau Mano from the Criminal Lawyers Association.
Hi, everyone. It's nice to be back here before the committee on behalf of the CLA, and also have some experience appearing before this committee when a lot of the mandatory minimum sentences in a previous government were introduced, as well as restrictions to the conditional sentence regime. I've been a criminal defense lawyer in Ottawa, Eastern Ontario, and Quebec for the last 14 years. Have seen, as a trial lawyer, the impact of mandatory minimum sentences on a practical as well as on a human level, as well as the limits to conditional sentences, and broadly speaking, the disastrous effects of the war on drugs, which is one of the greatest policy failures of our time. I have three broad points to make on behalf of the CLA about Bill C-5, and I understand Minister Lametti presented this bill as three broad areas of reform. Number one, dealing with mandatory minimum sentences. Number two, dealing with conditional sentences. And number three, dealing with prosecution for simple possession. CLA is broadly supportive of the first two measures because, in fact, what they do is they restore judicial discretion in sentencing on an individual level. On a fundamental level, we have faith in the justice system to get it right. We have faith in the process. We have faith in judges to be able to hear the evidence as part of the adversarial system, where the Crown marshals its best arguments and evidence, and the defense does the same, and the judge decides, and the judge gives reasons, and that judge is held responsible or accountable for their reasons through the appeal process. Mandatory minimum sentences, as well as conditional sentences, limit this and create a one-size-fits-all that often creates injustice and has broad negative impacts. So in terms of the first two areas of reform, We're broadly supportive of this because it restores judicial discretion and would call for the repeal of other mandatory minimum sentences. Because it's important to note that just because a mandatory minimum sentence isn't available does not mean that a person is going to automatically be sentenced to no jail. Primary example of this can be seen in the wake of the Supreme Court's decision in RV Newer NUR, in which mandatory minimum sentence for possession of firearms, certain instances, that was struck down. And it did not create this crisis in which all of a sudden people convicted of these offenses were not getting jail sentences. The second point I want to make is that as someone who is spending a lot of time in trial court, I can tell you that mandatory minimum sentences, as well as limits on conditional sentences, create delays in the justice system. They create delays because it makes people less likely to want to accept responsibility for what they have done and more likely to go to trial and consume valuable trial or court resources and time, which is at a premium currently in our criminal justice system. We suffer from very significant delays in our criminal justice system, which impacts everyone, including victims of crime. And not having conditional sentence available will often tip the scale in terms of whether a person decides to plead not guilty and have a trial, because they're going to lose their job if they're sentenced to jail. And it's important to note that the Crown and defense don't have to agree on whether or not a sentence of jail can be imposed. If a conditional sentence is available, an accused person can take a shot at it in terms of having their counsel argue as to why a conditional sentence should be imposed in this particular case. And part of what the court has to consider is whether or not a person is worthy of a less than 2-year sentence. If it's 2 years or more, it's simply unavailable. And also whether or not, if released on a conditional sentence, they would be a risk to public safety. Would they be willing or able, would they be able to follow those conditions? Can those conditions be enforced? And if it can't be shown that it can, then a person will not receive a conditional sentence. But at least through the adversarial system, an accused person can try and persuade the sentencing judge to give them a conditional sentence. And that will lead to the resolution of more cases. The last point with respect to simple possession is simply that the bill offers a great deal of discretion to police officers, in which it is my view that racialized and Indigenous groups will not be benefiting from this because of they're already over-policed. And this is not going to solve some of the problems which are seen in the war on drugs and with over-incarceration of those groups. So I look forward to speaking to the members individually.
Thank you. Thank you. Now over to Mr. Ewan from the Federation of Asian Canadian Lawyers.
Thank you. Good afternoon, everybody. Thank you for the Standing Committee for the invitation to present today. I'm a member of the Advocacy and Policy Committee of the Federation of Asian Canadian Lawyers, and I'm also a criminal defense lawyer. Largely speaking, FACL is supportive of Bill C-5 and the removal of mandatory minimum sentences. Repealing mandatory minimums will not make our communities more dangerous. It does not mean that the courts will be light on violence and dangerous offenders. Removing mandatory minimums will allow justice system participants to achieve reasonable and fair dispositions in an efficient manner. Regardless of whether mandatory minimums exist, sentencing precedents provide a tariff in which courts are guided towards sentences that previous offenders received under similar circumstances. A criminal charge captures a snippet of an individual's life. The trial itself then scrutinizes and dissects that moment. The crime is often the culmination of inescapable social circumstances and desperation. When it comes to sentencing, we must recognize that the offenders are more than their criminal charge. Along with addressing the harms done to the community, sentencing principles must focus on the individual circumstances, how and why they turned to a life of crime, what steps have been taken since being arrested, whether they can rehabilitate, and whether they can become productive and pro-social members of the community. I want to focus my time on how the removal of mandatory minimums can streamline matters through the system and how judges will be allowed to ensure proportionality between the sentence with the harm done. I was counsel on a matter where my 18-year-old client was charged with robbery with a restricted firearm. He was arrested with the gun less than 5 minutes after he committed the robbery. My client was young. He did not have a criminal record. During his time released on bail, he had taken meaningful steps to find employment and became involved with his local community. He never breached his bail. Knowing that his charge had a 5-year mandatory minimum, there was no real benefit in entering an early plea. The matter eventually made its way into Superior Court, and a 4-week judge and jury trial was scheduled. It became apparent that my client had great rehabilitative prospects, that a sentence lower than 5 years would be appropriate. Eventually, my client pled guilty to a lesser-related firearm charge, so to avoid the 5-year mandatory minimum. That disposition required substantial creativity from myself, the Crown, and the judge to find a way around the mandatory minimum. In doing so, requiring additional resources to fight the charges which drained valuable public resources. Without mandatory minimums, certain matters can be resolved in a timely manner. It prevents the court having to block off lengthy trials and prelims. Ultimately, it can alleviate the pressures that the courts are facing, especially during the current COVID-19 backlog. Turning to my second point regarding immigration. Serious criminality can result in mandatory deportation. A sentence over 6 months is considered serious criminality. For the benefit of the court information, oftentimes an accused person will actually end up spending a longer period of time in custody than is actually ever formally recorded. For example, if all parties agree that a 9-month sentence is appropriate and the individual has already spent 4 months in custody, often the judges will be explicitly asked to not note down the pre-sentence custody and simply sentence the individual to a further 5 months. In doing so, keeping the formal sentence noted on the information under 6 months. Mandatory minimums prevent any such discussions. Courts are asked to consider immigration consequences when determining a fit sentence. Asians will often fall under a wide range of statuses in Canada, ranging from being a visitor, holding either a work or student visa, and permanent residence. Being charged with a criminal offense can greatly affect their immigration status. Mandatory minimums increase resistance in both the criminal courts and the immigration system. Clients have to fight both. An informed member of the community would want judges to be able to have fair and open-minded discussions to consider the greater impact on the individual, their immigration status in Canada, how deportation can then affect the lived realities of any of the dependents that they possibly care for. Bill C-5 is not about being soft on crime. Those deserving of a long jail sentence will continue to get serious custodial time. In addition to addressing the over-incarceration of people of color and Aboriginal offenders, Bill C-5 is about giving judges the discretion to ensure that justice is served in a proportionate manner. Thank you, everybody, for your time.
Yun. We'll begin our first 5-minute round with Mr. Morrison.
Thank you, Mr. Chair. And I'm going to try and get everyone, but I'm limited in time. But I'm going to start off with Ms. Dover when I get to a question. I just want to kind of just go over. We had one of our last witnesses was the Six Nations chief, and he was talking about the escalation in offenses. And when we're talking elimination of mandatory prison time for things like weapons trafficking and discharging firearm with intent and robbery and extortion, adding to that, eliminating mandatory prison time for drug dealers, trafficking and production of fentanyl, crystal meth, cocaine. And the chief was saying that those are what's common now where he's policing, and that to eliminate the mandatory prison time would have actually an adverse effect. And then add to that, we're talking about conditional sentencing, where people are could get conditional sentences for sexual assault, trafficking in persons, abduction of a person under 14, assault causing bodily harm with a weapon, and then these people are put back into the community to live, and now there's retaliation happening now from the victims. And sometimes it appears to some of the people we've talked to that the victims' rights are kind of being undermined a bit by trying to maybe help or do something more with the offenders. So my question is really, I think we really have to look at how did we get to the point. So, Ms. Dover, with you and you really had a really good story with the prison art, and I've got quite a career in law enforcement, so I do understand that. I guess, when we look at how can we actually forget this and talk about, is there some way that we could actually go back into like restorative justice, I think is great for after the fact, but how do we get into, say, a crime reduction program, crime prevention, where we actually prevent crime from happening? So we did have one witness quite a while ago that talked, it was a 15-year program that they were involved in, that they started off with 4, 5, 6-year-old children and worked all the way through to give them choices, to show them what was right, what was wrong, and had huge success. But the problem with those crime prevention programs is they're long-term and they're very expensive. And I know you've also had some dealings with the Indigenous Peoples Court in Ontario, which could be expanded as well. So I wonder if you can maybe just comment a bit on your expertise and maybe helping us go further with a long-term solution that you might have in mind.
Thank you so much for your question. I appreciate it. I want to say a couple of things. If you bring a plumber to your house and ask for input on a renovation, she's going to point to your pipes. So I understand that the chief of police thinks about the types of solutions to underlying problems that might be available to criminal law. I respect Chief Montour as well as a member of the community and a leader of the community, but I want to tell you something. In a triple murder case from that community, 2 of the victims were former clients of mine. And 2 of the 3 significant charged people were former clients of mine. And one of the people that I talked about in sharing the anecdote to you about eulogizing them and remembering the laughter was one of the victims. Like the people, we have this idea that there are victims on one side and offenders on the other. And there are not 2 camps of individuals, particularly for racialized people, they are one. So there are roadmaps that are set out in the Royal Commission on Aboriginal People, on the TRC, on Missing and Murdered, where Indigenous people have shared with us how to move forward from the history of colonization and racism to be reforming criminal justice. And we just need to listen and follow through. And a key thing that they've said over and over again is mandatory minimum sentences have to go, because they are not the solution to the underlying problem. We cannot fix the fact that the Canadian criminal justice system has not earned the trust of Indigenous people through mandatory minimum sentences. And if you really want to empower victims, put some teeth behind victim rights legislation so that Crowns stop treating them like they are guidance, and to give victims genuine participatory rights as well as the ability to be involved in meaningful ways.
Okay.
Thank you. Next, we'll go to our next round where Madame Briard for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. My question is Ms. Dover. Can you hear me, Ms. Dover? Do you have the interpretation? With the Gladue decision of the Supreme Court that recognized the overrepresentation of Indigenous people in prisons and asked judges to take care of systemic and historical factors when doing the sentencing, and with the abolishment of some CSO's approach where one size fits all, and the question of conditional sentences, do you think that we should respect and follow the recommendations in the Gladue case?
Thank you for your questions. Yes, we should follow Gladue, but it is broadly misunderstood. So Gladue was the second case in time that formed a bridge between the Royal Commission on Aboriginal People, the history of colonization, the breakdown of the relationship between Canada Indigenous people, and bridged that background then into criminal law to say, how do we move forward constructively given the reality of systemic racism. So Gladue has become narrowed, misunderstood as a clarion call for rehabilitation and restraint. What it was really meant was to create creative space for judges in different contexts to try and divine different ways so the system is less racist. Until we get to a point where we're able to openly, expressly challenge systemic racism, then we will continue to fall back on familiar ways of doing things, familiar stereotypes in the way that we're thinking, and we'll fail to actually reduce the number of people that are in the criminal justice system and to make sentences in the context of Gladue meaningful for Indigenous people.
Thank you. Thank you for this response. Maintenant, j'aimerais...
My next question is for Mr. Russomano. The Supreme Court explained that, generally speaking, a conditional sentence is more effective than incarceration when it comes to rehab and reinsertion into the community, and in making the offenders more responsible. Has that been your experience, in fact? Is that true?
Thank you for the question. A conditional sentence has very practical effects in the sense that if you have an offender who is being sentenced, a conditional sentence has the ability to combine more rehabilitative components that enable a person, once they've finished their sentence, to actually not go back to a criminal lifestyle. I mean, drug trafficking is an obvious one in terms of, drug trafficking is when it's not motivated by addiction, it's motivated by profit, the desire for profit. And when a person comes out of jail without any prospects for employment, it's a lot easier to fall back into that lifestyle, whereas a conditional sentence would allow a person to remain employed, would allow a person to access better health care, better mental health counseling, or other forms of counseling or other forms of rehabilitative programming that just wouldn't be available while incarcerated. So in that sense, a conditional sentence is infinitely better in terms of reintegrating someone into society and provide that they rehabilitate properly.
Thank you. And for Mr. Yuen, vous avez mentionné...
My next question is Mr. Yuen. You mentioned that judges who could improve administration of justice by abolishing some mandatory minimum sentences with C5. Do you think the judges are going to have the opportunity to issue sentences that are more adapted to sociocultural situations?
I believe so. I believe that judges often do take into consideration the full background of an offender, and the alleviation of mandatory minimums opens the door up for judges to take every circumstance into consideration about themselves, the offender, their background, rehabilitation prospects, and family or other individuals they care for as well. So certainly I do think so, yes.
Thank you. Next, we'll have Monsieur Fortin for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I would like to ask a question of Ms. Dover for a few minutes. From your presentation, I understood that there were problems with resources in the community. You say that there are, for example, some pregnant women who get out of prison and they don't know where they're going to sleep that night. You talk about people who are found guilty without having heard their entire story and without even knowing about the behavior that we're trying to correct. You mentioned a number of things that lead me to think that really there is a problem with resources. I'm not saying that this isn't the case, but you also added that the victims and the accused live in the same community. You yourself had a client as clients, 2 accused, and then the victims in the same case. I don't know how to call this, but it seems to me that those people have to learn to live together. And what I can gather is that behavioral changes are needed. So in that regard, don't the victims need to feel that the judicial system thinks of protecting them? And in that case, well, I understand that there are extenuating circumstances where we would say that minimum sentence should not apply. That's clear. But generally speaking, do you think that maintaining minimum sentences isn't better for the social fabric rather than say we're going to abolish them and then the victims of those crimes are going to end up overnight with the same individuals who, based on the same principles, if you look at the way the criminal code is drafted right now, should end up in prison? Don't you think there are things that can be done to better protect the victims?
Fortin.
Thank you, Mr. Fortin.
With thoughts about victims, what if we had a criminal justice system that responded to victims by saying that never should have happened to you? What if there was a measure of accountability when recidivism happened and offenders that had been to jail and been through the system and not been helped? They were still homeless. They still suffered from addiction. They never got counseling they desperately wanted. What if there was some mechanism of accountability for them? What if victims genuinely had a voice within the system? What if they didn't have to have their voices moderated through Crown attorneys or victim services and they had the role? The idea that a victim wants a template number, you know, like the ingredients on a bottle of barbecue sauce, like, oh, for this offense, you get 6 months. That's what you're worth as a victim. Victims want to be integrated so that their stories matter, so that there is a connection to the court in the way they are considered, and the principles of sentencing have that as their idea. There's no such thing as a conditional sentence that should be ordered where there are public safety grounds and where victims are able to have a voice, a real voice, not a pretend voice where we give them a number for an offense that happened to them. Then we make a justice system that is more meaningful not only for victims but for everybody. There's no such thing as a meaningful number, I don't believe, for any victim.
So abolishing all minimum sentences, as is proposed by C5, if I followed you, that would send the wrong message to victims. We have to be careful with that. But would you agree that in some circumstances, we've heard about this in various testimonies, that there are circumstances where someone, in an ideal world, would not have to serve a prison sentence. They could have had a suspended sentence, for example. Perhaps in exceptional circumstances, you could go against the rules. But now, if we abolish minimum sentencing, that would be quite the message that we were sending out.
So think about sentences, for example, for aggravated assault. So these are circumstances where somebody just beats the living tar out of somebody, not to the level of an attempt murder, but really bad, maiming, injuring. In that circumstance, we have a dialogue, stories within the justice system that ensure there are jail responses to serious offenses. We do not need mandatory minimum sentences to respond effectively to victims in that way.
Thank you, Monsieur Fortin. Now to Mr. Garrison for 5 minutes.
Thank you very much, Mr. Chair. Mr. Guan, you mentioned something that has not been brought up in these hearings before, and that's the issue of deportations as a result of mandatory minimums. What would you say to those people who say, well, they did the crime, they should be deported? What happens to families, and what happens when there's a deportation?
Well, it depends on the circumstances. For example, before the arrival of mandatory minimums, let's say, for example, production of marijuana has a mandatory minimum of 6 months. Oftentimes, new immigrants or people who come to the country without many resources will take the first housing opportunity they can get. And especially in the Asian community, we had elders who took up housing in overpopulated houses where there weren't sufficient rooms. And essentially, they were lived-in tenants for the landlord to then go about their production of things that they had nothing to do with, nothing that they knew about or was part of, but they were there. So they were charged. And the minimum is 6 months. That's deportation. That takes into consideration about perhaps other people they care for. Say, for example, you have a young mother, single mother, who is facing deportation. Now they have to leave the country. What about their young child who's in the country? Maybe they're Canadian born, maybe they're not. Do they leave it with social services, with family members? Do they take the child with them? Those are considerations that extend beyond the criminal sphere, so to speak, but into the livelihoods of the offender and those they take care of and those around them.
Thank you. I know in my writing we have seen consequences where the sole support of elderly parents is being deported for something that most people wouldn't have thought deserved that harsher penalty. I want to turn to Mr. Russomanno on the question of discretion. I think that's something we haven't discussed enough in these hearings. And your opinion that the discretion to charge will not necessarily benefit racialized and Indigenous people. Could you tell us a bit more about your analysis of that discretion?
Yeah, thanks for the question. Well, practically speaking, when a person comes into contact with the criminal justice system for, let's say, simple possession, one of the things that a police officer may do is, and most often will do, is to check their police records to see how many contacts that person has had with the police. And so it doesn't take too much, mental energy to figure out that racialized groups and Indigenous groups who are over-policed, who are overexposed to the criminal justice system will only be further disproportionately affected by leniency that is rooted in police discretion, because we have seen time and time and time again that when you provide those persons with a wide degree of discretion, that it is disproportionately negatively impacting racialized groups. So a person who is found by a police officer smoking cannabis in their upper middle class neighborhood is going to be dealt with leniently, and a person who is found in a lower class or a subsidized income neighborhood that's over policed, who's had a number of contacts with the police, even if they weren't found guilty, is not going to get the benefit of the doubt. And that's how, in my view, that's going to play itself out.
Bill C-5, as it's drafted, doesn't require keeping any records on the exercise of that discretion. I wonder whether you would be concerned about that, in the sense that how we know who's benefiting from the discretion if the police aren't required to keep those records?
Yeah, I mean, in many different ways, I guess the failure to keep those records is going to have an impact just in terms of being able to track how that discretion is used. The simple solution to this, and I guess I was slightly encouraged to hear Minister Lametti express that is something they're looking into, is to decriminalize all simple possession offenses. If we're talking about people who are using drugs for their own personal use, it is a healthcare issue. And if it's a matter of there being concurrent criminal offenses being committed, well, then those offenses can be prosecuted. But to resolve the situation of people who are prosecuted for simple possession by continuing to prosecute them, I mean, what better evidence is there of the abject failure of that than the last several decades of a failed war on drugs?
Bill C-216, which is coming before the House of Commons for a vote on decriminalization of simple possession. So that's a different process from this one, but it will be coming forward, and I see that I am out of time. Thank you, Mr. Chair.
Thank you, Mr. Garrison. I can do two quick 3-minute rounds just to go over 6 minutes if I have the consent of the committee. Otherwise, we'll have to wrap up as it is 5:30. Okay. It might be tough. It'll go to 10 minutes. It's the will of the committee. Fine to wrap up? We'll do two 3-minute rounds, and then we can wrap up. Okay. To Mr. Moore for 3 minutes.
All right. Thank you. Thank you, Mr. Chair. I want to ask a question to Mr. Russomanno. Appreciate all of you for being here today, and you've all brought your perspective to this bill. It's no secret that we've raised some concerns about the legislation. You mentioned your involvement in the past when the previous government was bringing in some changes to conditional sentencing as well as mandatory minimum penalties. I can tell you that one of the great ironies of this bill is, in spite of what the talking points are, that this is about maybe getting rid of mandatory Harper-era mandatory minimums. The irony is that the minimums that are being contemplated removed in this legislation, some of them go back to the 70s. They certainly go back to the 90s. And many of the mandatory minimum penalties, particularly some escalating ones around gun violence, the government has that came in under a previous Conservative government, the government has chose to leave in. So do you feel that there is any place for mandatory minimum penalties in the criminal code at all? We know there's a mandatory minimum penalty for example, first-degree murder. We know that some serious firearms offenses have mandatory minimum penalties that is not touched by this legislation. So from that starting point, do you believe that there's any role for mandatory minimum penalties?
Thank you for the question. I think from your perspective, and I heard one of the members in a previous discussion with Ms. Shanmuganathan say, mandatory minimums serve a purpose of Parliament expressing a denunciation or expressing a revulsion to certain crimes. And I suppose that on a theoretical level, it certainly has that effect and it has that use. Do I personally believe that mandatory minimum sentences are necessary? No, I don't believe they are. I don't think that there's going to be judges on first-degree murder sentencings who are going to be sentencing people to conditional sentences. I think that judges do take into account victims of crime. I think that they're very mindful of the impact that these crimes have on the community. And if you go to a sentencing courtroom for first-degree murder, I think you'll see that that is actually what's taking place. So no, I don't believe that, because I believe that judges have to be accountable for their decisions, and they have to provide reasons, and they have to consider certain factors. And first-degree murder is the most serious crime in Canada. I don't think there is actually a need for it in court, though I do understand how, as parliamentarians, you might feel like that has some sort of communicative effect to members of the community. I think it does more harm than it does good.
Thank you, Mr. Moore. To Mr. Zuberi for 3 minutes.
Thank you, Mr. Chair, and thank you to the witnesses for being here today. My first question is for Mr. Russomanno. It's in relation to your third point that you mentioned in your opening remarks, that you say that the Criminal Lawyers Association has hesitation around the aspect of simple possession. If we were to keep the spirit of what is there currently in the bill, but we want to mitigate for what you identified, which is the wide discretion to police and how that can unwittingly continue the overrepresentation of Indigenous and Black communities. What would you recommend for us to do while maintaining what is there? Would you, for example, recommend some new wording, language, or certain guidelines to be added?
Thank you. That's a complicated question, I guess, because fundamentally, we're against the sort of structure that's being proposed because of the injustices that it perpetuates. But you're asking me what sort of changes I would make within that structure. I would say that, for example, police officers should not be in any way basing their discretion on the number of police contacts that a person has had in the past, and that they should have to take into account whether a person is racialized or Indigenous or otherwise a vulnerable member of our society, or someone who's overexposed to the criminal justice system. But that discretion isn't really reviewable, so I think it's kind of ineffectual.
question again for you is that, from your perspective, does the tough on crime approach really help reduce crime, or does it increase injustice towards Indigenous communities and other racialized communities rather than really address the intent to reduce crime?
Right. I think that everybody probably knows that the tough on crime model has not done anything in this country or in any country to lower crime rates or to keep people safe. I listened intently to Chief Montour talk about the issues that are plaguing his community, and I can't speak to the individual or specific issues in that community. But something that did strike me is the comment that, serious drug trafficking has gotten worse, violent crime has gotten worse. And I thought to myself, well, all of that has happened under the guise of increased mandatory minimum sentences for violent offenses through successive tough on crime models being imposed. And what do we have to show for it? We have to show overcrowded jails, money spent on incarcerating people and not keeping Canadians safe in the end. So I think as they say, the proof of the eating is in the pudding.
Thank you, Mr. Zaberi, and thank you to all the witnesses for your invaluable testimony. I will now conclude this meeting and see everyone else on this committee on Friday. Thank you.
Thank you.